Okay, good afternoon, everyone. Mark and I are delivering the first session this afternoon. We're going to be covering deportation and exclusion. We're going to be having a look at what the current law is for EU nationals and their family members facing deportation and exclusion, how that is changing. We're also going to have a look at suitability grounds of refusals under Appendix EU, rights of appeals, and finally, good character issues for nationality applications, as that seemed to flow quite well from suitability issues, and then losing settled and pre-settled status through absences, which will be quite brief on, but we'll look at the main points. So there's quite a lot of material to go through, so I'll make a start. And I'll start by having a look at what the current laws are in respect of deportation and exclusion for EU nationals and their family members. Mark, thank you very much. Okay, so currently suitability issues don't arise under the EEA regulations and the directive. EEA nationals are exempt from immigration control, so suitability issues simply do not arise. However, under Appendix EU, there are suitability grounds for refusal, which we'll go on to look at a little bit later. However, EEA nationals and their family members are subject to exclusion and expulsion, and that's on the grounds of public policy, public security, and public health. Now, the relevant tests that apply, they're set out in Articles 27 and 28 of the directive, and those are transposed into domestic law through EEA regulations and currently in Regulation 27 and Schedule 1 of the EEA Regulations 2016. If you are subject to a decision on this basis, there is a right of appeal to the tribunal under Regulation 36. And what I've done at the bottom of this slide is I've put in a hyperlink to the policy guidance that addresses all of these tests so that you're able to access that in more detail. Okay, so we currently have the tests that apply, we currently have a tiered system. And how it works is that it depends on your length of residence and whether or not you have a permanent right of residence. Your age as well is relevant. So working through those tiers. So first of all decisions on this basis, they have to be based on grounds of public policy or public security. Now, individuals who have a permanent right of residence, so that means that they have to meet Regulation 15 of the 2016 regulations. So in summary, have been residing in accordance with the regulations for a period of 5 years. For those individuals, the decisions have to be based on serious grounds of public policy or public security. Now, if an individual has been residing here for 10 years, or they're under the age of 18, then a decision on this basis can only be taken if there are imperative grounds of public security. And now the following principles apply to all decisions on this basis. So the individual has to present a genuine, present and sufficiently serious threat affecting one of the fundamental interests of society. Now, Schedule 1 of the EA Regulations 2016, that sets out a list of what they consider to be fundamental interests to society. But just breaking down those words a little bit, genuine, present and sufficiently serious threat, in their own policy guidance, how they define that is that the threat has to be a realistic one and it must exist currently. Taking the next two bullet points on your slide together, matters have to be based exclusively on the individual's conduct, matters isolated from the case or which relate to considerations of general prevention are insufficient. So when Mark goes on to look at how the laws are going to change, and those of you that are familiar with the deportation immigration rules in section 117A to D, you will know that considerations of general prevention are important in UK deportation law. So case law often refers to the deterrent effect that deportation has on foreign nationals committing criminal offences, and also how it's an expression of society's revulsion of individuals committing serious crimes. Now, under EU law, those considerations don't apply, but as Mark will explain, going forward, they will. Previous convictions alone are insufficient, and a decision has to comply with the principle of proportionality. Now, what that means is that the measures taken to restrict the individual's rights of free movement and residence, they must be necessary and appropriate to protect the fundamental interests of society. And they also have to have regard to factors such as age, state of health, family and economic situation, length of residence, and social and cultural integration. Those are the tests that currently apply, and as Mark will explain, they remain relevant going forward. Now, as I had said, there is a right of appeal to the tribunal if you're facing a decision to deport on this basis. However, under Regulation 33, an individual can be removed pending the outcome of their appeal, where the Secretary of State has made a decision to certify that despite the appeals process having begun, and not being finally determined, their removal would not be unlawful under Section 6 of the Human Rights Act 1998. Now, part of the basis on which they can certify under Regulation 33 is that it includes that a person would not face serious irreversible harm if they're removed pending their appeal. Those of you that are familiar with deportation will know that is not the sole test, and Kieran Binlos made that quite clear in the Supreme Court decision. The question is whether removal pending appeal breaches the individual's human rights. But there's been a recent case from earlier this year called Hafiz, which makes clear that the decision to remove pending appeal, it must also be proportionate and in accordance with EU law. So they have to have a look at whether or not the threat that's posed by the individual actually meets the relevant EU law tests, which we've just had a look at. Now, an individual that's removed pending appeal, they do have the ability to re-enter for their appeal hearing, and that's dealt with under Regulation 41 of the 2016 regulations. Again, just at the bottom of the slide, I've put in a hyperlink to the relevant guidance on Regulations 33 and 41. And as I say, this remains relevant, but I will now pass on to Mark, who's going to explain how.
Thank you, Priya. I shall be focusing at the outset on the new deportation framework for EEA nationals. And in so doing, what I'll be looking at is the position in relation to existing deportation orders, what happens in the future, and what happens in respect of deportation orders made during the grace period against EEA nationals and thereafter. I think in one of the earlier sessions, reference was made to the number of sources of law in this area, and I would reiterate what Alan Briddock said earlier, that the starting point it's important to go back to is the withdrawal agreement. And in this context, what we're talking about in particular is Article 20. That is given effect to by the European Union Withdrawal Agreement Act 2020, which we'll come on to have a look at. Then we have the Citizens' Rights Appeals Regulations made in January of this year. They set out appeal rights for those who already have settled status. So those are relevant where deportation orders are made in the future. And then we have the the grace period regulations covering the period from January to June 2001, January to June 2021. And finally, the Immigration and Social Security Coordination EU Withdrawal Act 2020 Consequential Saving Transitional and Transitory Provisions EU Exit Regulations 2020, which I'll refer to as the transitional regulations, and they deal with the position after the end of the grace period. Article 20, that is important because it makes clear that the position moving forward in respect of EEA nationals is that any conduct of theirs that occurs up until the end of the transition period, or IP completion day, the end of this year, 31st December at 11 o'clock, falls to be considered in accordance with Chapter 6 of the 2004 directive. What does that mean in practice? Well, it means basically that if you are convicted in 2021 or at any point in the future, you will still be entitled to rely on the principle in Article 20, irrespective of the date of the conviction, irrespective of the date of the deportation order. And so what is critical is the date of the conduct of which normally is the offending behaviour giving rise to the deportation order. Coming back to the starting point, we're all familiar with the automatic deportation provisions. We have the principle that deportation of a foreign criminal is conducive to the public good, the deeming provision where somebody receives a sentence of imprisonment of 12 months or more. And as we will see, that is going to be applicable to all EEA nationals in the future. But if we move forward to the next section, 33 exceptions, we'll see that inserted into the UK Borders Act 2007 by the European Union Withdrawal Act 2020 is section 6b, which effectively incorporates Article 20 of the withdrawal agreement. So the government has, it appears, faithfully reflected what is in the withdrawal agreement on this particular occasion. It's worth just noting the words in 6b consisted of or included conduct that took place before 11 p.m. on the 31st of December 2020. So as I've suggested there, you could have a situation where many years from now somebody is convicted of, for example, historical sexual offence. Often with such matters, there is a count on an indictment that covers a wide period because it's difficult to identify specific dates. And if that period was, for example, from the 31st of December 2020 to the 31st of June 2021, then it appears, based on those words, that the person in question would be able to rely on the elevated protection within Article 20. Moving forward, the position in relation to existing EEA deportation orders, what happens with those? Do they automatically disappear at the end of the transition period? Well, unsurprisingly, that isn't the case, and the transitional regulations make provision for them to continue to apply until they are revoked. So that's relatively straightforward. The position in relation to deportation orders in the grace period is addressed in the grace period regulations, and you'll see regulation 3 sets out what the grace period is at subparagraph 5, And then at subparagraph 2, you have reference to regulations 5 to 10, which are preserved during the grace period with modifications. So one of those provisions is regulation 7. And what that does is to preserve various matters at subparagraph 1A. We have the preservation of regulation 23.6b, which is the provision in the 2016 EA regulations, which Priya was just discussing, which enables deportation orders to be made on the grounds of public policy, public security, or public health. And then we have F, regulation 27, but we have a new 27A inserted there. And you'll see 27.1, an EA decision may be taken on the ground that the decision is conducive to the public good. So we've got the new test there that's going to be applicable to EEA nationals. But subparagraph 2, a decision may only be taken under this regulation in relation to conduct as a result of conduct of that person that took place after IP completion day. So what we have there is, again, a reflection of exactly what is said in Article 20 of the withdrawal agreement. If we move on, we've got Regulation 9, which preserves the appeal rights in the EEA regulations. So we can see there that effectively for the grace period, we've got full preservation with some modifications of the 2016 regulations. And the net effect of that appears to be that in an appeal, an EA deportation order can now be made where an EA national no longer has the right, the elevated protection. However, he will continue to have the elevated protection, provided that the conduct in question is before the end of this year. It's worth, I think, pausing to consider just how many of these orders are likely to be made under the grace period regulations. What we're talking about here is a period of around 6 months. And in that period, you're going to have the conduct, the offence, the investigation, the conviction, the sentence, and then the order. Given the difficulties at the moment, particularly with Crown Court trials and the delays, I would venture to suggest there aren't going to be that many orders. Perhaps somebody pleads guilty at an early stage to a very serious offence. But in that scenario, where they are subject to an order under the 2016 regulations, if it is based on conduct from January onwards, then the fact that they can rely on the 2016 regulations doesn't assist them, because as we've just seen, there is no elevated protection for them any longer. So moving on to the position of deportation orders and those with settled status, and I've posed the question there: how does an EEA national with settled or pre-settled status challenge a deportation order? There is a specific provision within the Citizen Rights Appeals regulations, Regulation 6, which provides a right of appeal against a decision to make a deportation order. As we can see, that is effectively an appeal under the 1971 Act, because subsection 3 excludes appeals taken under, in respect of decisions taken under 23.6b of the 2016 regulations. And if a decision is taken under that provision, then the the grace period regulations that we've just been discussing will apply. Grounds of appeal. Again, Regulation 8 is the important one. This doesn't just apply, as we'll see in due course, to deportation orders, but the important point here is 8.2. The first ground of appeal is that the decision breaches any right which the appellant has by virtue of Chapter 1 of the withdrawal agreement. Now, the withdrawal agreement, Chapter 1 of the withdrawal agreement includes Article 20. So that is the mechanism by which that right in Article 20 is preserved in respect of those with settled status. As I've indicated at the bottom there, if a deportation order is made against a person with settled or pre-settled status, which will be the only possibility after the end of the grace period, it will still be possible to rely on rights contained in the 2016 regulations by virtue of Regulation 8.2a, even though the 2016 regulation regime will effectively come to an end. I'm going to talk about deportation appeals now in respect of the 2016 regulations. So the question here is, what happens if an EA deportation appeal has not been determined by 1st of January 2021? And so we come back to the grace period regulations, which cover the initial 6 months, and the transitional regulations, which cover the situation thereafter. In respect of paragraph 5 of Schedule 3 of those transitional regulations, the regulations preserved under paragraph 6 include all the ones that we're concerned about here. So Regulation 23.6b, Regulation 27, Regulation 27a, which I discussed earlier, and Regulation 36 regarding appeal rights. So all those things are preserved in respect of appeals. So we shouldn't be in a position where there's any situation where there's any rush to resolve an appeal in order to meet a particular deadline. It appears that the law should be preserved until those cases are dealt with. And of course, that's particularly important at the moment because of the delays in the tribunal system. So in summary, the position is that outstanding appeals, as I've just mentioned, will continue to be considered under the 2016 regulations. Deportation orders will continue to be made under the 2016 regulations during the grace period. But if the conduct was on or after the 1st of January 21, due to Regulation 27a, there's no elevated protection of the like which Priya was describing earlier. After the end of the grace period, anyone granted settled or pre-settled status who is made the subject of a deportation order can appeal on the basis that it is contrary to Article 20 of the withdrawal agreement. And we've seen the way that that mechanism is brought about. So their conduct before the 1st of January must be considered in the light of the 2016 regulations, the Citizens Directive. The last point that I've raised there, if an application for settled status or pre-settled status is refused on the basis of conduct, then an appeal can be lodged and the appellant will be able to rely directly on Article 20 of the withdrawal agreement. That is effectively based on a discrete topic which I'll come on to discuss in a little bit more detail later on. But hopefully that provides a summary of the way in which all these provisions interact, so that we can start to see how these cases are going to be dealt with in the future and to fit individual cases into that framework. It's not particularly straightforward, but it may be one of those things that once we've got our heads around it, then it does become workable. Well, I'm going to hand back at this point to Priya, who's going to talk a little bit about suitability under Appendix EU.
Thank you for that, Mark. Okay, so as Mark has said, I'm going to now move on to address refusals on grounds of suitability under Appendix EU 15 and Appendix EU 16. There are mandatory grounds of refusal and discretionary grounds of refusal on the basis of suitability. So starting first with mandatory grounds of refusal, those are quite straightforward. So under Appendix EU 15, an application will be refused on the grounds of suitability where an applicant is subject to a deportation order or a decision to make a deportation order or an exclusion order or decision, and really that's it. An exclusion decision is defined in Annex 1 of Appendix EU. It's basically a direction given by the Secretary of State that a person must be refused entry to the UK on the grounds that their presence would not be conducive to the public good. And a deportation order is an order made under Section 5.1 or Section 3.5 of the Immigration Act 1971. And it includes automatic deportation under Section 32 of the UK Borders Act 2007. So let's move on to look at discretionary refusals on suitability grounds. Now, those are addressed in Appendix EU 16. And what that says is that for all of these sorts of applications, what there needs to be an assessment of proportionality. So whether it is proportionate to refuse on suitability grounds. There's 4 different suitability grounds that arise on this discretionary basis. And the first of those, Appendix EU 16A, this is where an individual has used dishonesty or deception in an application. And what the rule says is that where an individual has submitted false or misleading information, representations or documents in support of their application, and that information, the representations or documents are material to the decision whether or not to grant the individual leave, they may be refused. Now, the policy guidance, the suitability policy guidance, which there is a link to in the slides, is really very useful for decisions that are made under Appendix EU 16 subparagraph A. Now, first of all, what it does is it gives examples of the sort of circumstances where they would consider that there's been dishonesty. So, for example, somebody claiming that they have been here for 5 years when they haven't. What it makes really very clear is that the dishonesty or deception has to be material to the decision to grant leave. So that's different to the position under the immigration rules under 321A, where there isn't this reference to materiality. In terms of other important things that are brought out in the guidance on this rule, AA Nigeria, the 2010 Court of Appeal decision is highlighted. And of course, for there to be a decision to refuse on this basis, there has to be deliberate dishonesty or deception or intent on the part of the applicant. It has to be deliberate. Errors and mistakes, they're insufficient. The guidance also makes clear that the burden is upon the Secretary of State to show that the individual has provided false information or representations or documents, and they have to have evidence to support the allegation. Now, it does say that discrepancies between documents and their records and previous applications, that might be sufficient in terms of evidence. The burden is also upon them to show that the applicant has been involved in deliberate dishonesty. Of course, the burden remains on the applicant to show that they actually meet the requirements of the rules. A really important part of the guidance to highlight is that it says that an individual who's going to be refused on this basis, they have to be subjected to a minded to refuse procedure. Now, what that means is that the Secretary of State has to write to them and say that they believe that they may have been involved in dishonesty or deception, and that they're considering refusing their application on this basis, and they have to specifically set out what the allegation is. The applicant has to then be given a reasonable opportunity to respond. And in the guidance, that said that they should be given 14 calendar days usually to reply. And then finally, a decision has to be proportionate, even if there has been dishonesty or deception. Now, what the guidance says is that they'll look at the seriousness of the dishonesty or deception, the impact that the refusal will have upon the applicant or their family members, and anything that the applicant sets out in their representations in the minded to refuse procedure or at an earlier stage. Okay, so moving on to Appendix EU 16 subsection B. This is quite a straightforward one. So if an applicant has been subject to a removal decision under the EA regulations for non-exercise or misuse of rights, then they can be refused on suitability grounds. Now, the guidance makes clear that a student or a self-sufficient person not having a comprehensive sickness insurance, that isn't enough for there to be a removal under the EA regulations for non-exercise of treaty rights. Also, what it says is that if a caseworker is considering an individual being referred for removal under the regulations for non-exercise or misuse of rights, they have to consult with a senior caseworker and also with the European Migration and Citizens' Rights Unit. Okay, so the next two grounds that arise, those are quite straightforward too. So if you have an applicant who has been refused admission to the UK under Regulation 23, or if they held leave under Appendix EU, which was cancelled under paragraph 321B, and that's already on the basis of public policy, public security and public health, then again, they can be refused if they go on to make a new application under Appendix EU. And then finally, if an individual has been excluded from refugee protection, then they are a relevant excluded person under Annex 1 to Appendix EU, and they can be refused on suitability grounds. But again, a decision has to be justified on either EU law grounds if their conduct was prior to the 31st of December 2020 before 11 p.m, where it's after that point, if the decision is conducive to the public good and it's proportionate, then they can be refused on suitability grounds. Okay, so moving on to the next slide. Now, all of you may have applicants who are really worried about making applications under the EU settlement scheme because of potential criminality conduct or pending prosecutions. The policy guidance is quite useful for applicants who are worried about their situation. It sets out the circumstances in which an individual will be referred to immigration enforcement, and it also explains when an individual is unlikely to be. So first of all, as was said in the panel discussion right at the start, applications are checked against the PNC and the warnings index, where an applicant is aged over 10. The decision maker will have a look at what comes up from those checks and make a decision as to whether or not they should refer an individual to immigration enforcement because of their conduct. If an individual is already subject to deportation or exclusion, then we know because of EU 15, there's going to be a mandatory refusal. If, however, there is a referral to immigration enforcement, what the guidance suggests is that they will let that situation be considered first. And if the applicant is going to be made subject to a deportation order or exclusion order, then of course what will follow is a refusal under EU 15. Okay, so what sort of circumstances might result in a caseworker referring an individual to immigration enforcement? So the policy guidance gives these examples. So where an individual has in the last 5 years received a conviction that's resulted in their imprisonment, they'll be referred. If an individual has at any time received a conviction which has resulted in imprisonment of 12 months or more as a result of a single offence, then they will be referred. If an applicant has in the last 3 years received 3 or more convictions, and that includes non-custodial sentences, unless they've lived in the UK for 5 years or more, then they will be referred. However, one of the convictions has to have taken place in the last 12 months, and at least one of these convictions has to have been in the UK. If the individual is in prison, they may already be of interest to criminal casework for exclusion or deportation, so it's likely that they too will be referred to immigration enforcement, and the guidance does include that, although that bullet point isn't on here. Now, what the guidance says is that if you have an applicant who's made an application under the EU settlement scheme, and they are already subject to deportation or exclusion, then they should be referred to immigration enforcement automatically. However, an individual may be subject to a deportation order, but it might be that 2 years have passed since that point and no removal action has been taken by the Secretary of State. Now, what the guidance says is that in those circumstances, immigration enforcement should look to whether there's been a material change of circumstances since that order was made. There's also quite an extensive list given of cases where there should not be a referral to immigration enforcement. Now, I haven't included those on the slide, but some of the important ones are if there's already been a decision made by the Secretary of State not to pursue deportation, if they've made a decision to revoke a deportation order or an exclusion order, and there's been no further conduct that meets the criteria for a referral to immigration enforcement, where they've already had an appeal that's overturned a decision to deport, then they shouldn't be subjected to that procedure again. What about individuals who have pending prosecutions? So they've been arrested or summoned and their offences are have not yet been disposed of, or they're subject to live investigations for suspected offences. Well, what the guidance says is, firstly, there needs to be a consideration of whether or not their offence meets the referral criteria. If it doesn't, then they can simply go on and process their application. If, however, it does meet the referral criteria, what the guidance says is that they can put an application on hold, and they have to decide whether or not it's reasonable and proportionate to do that. Now, if it's very likely that the criminal proceedings are going to take a very long time, the guidance does say it may be unreasonable to pause the application, and it may be better to make a decision on the EU settlement scheme application and then later see whether or not deportation arises. Okay, thank you. I'll pass back to Mark now, who's going to deal with rights of appeals.
Thank you, Priya. I'm going to talk very briefly about the position in respect of appeals against settlement scheme decisions, and this very much follows on from what Priya was discussing in terms of those things which may cause problems when somebody applies under the settlement scheme. We know that if that person is subject to a deportation order, that's an automatic no. And we also know that whether or not it's disclosed in the application, that checks are going to be made, and those checks can trigger consideration of a deportation order being made. So a deportation order may follow, and if that occurs, then effectively there appears to be some overlap in terms of the appeals process, because there's a right of appeal to against the refusal as well as against the deportation order. But I just want to focus now on the appeal rights in respect of decisions. And so we're looking here at again, the Citizens' Rights Appeals regulations from January. And in respect of decisions, that there are two grounds of appeal. The second one is effectively the argument that you should have qualified under the settlement scheme when the Home Office says that you didn't. But it's 8.2a again, which I want to mention, because that is the situation where, again, it appears that it's possible to appeal on the basis that the decision breaches any right which the appellant has by virtue of Article 20 of the withdrawal agreement. So what does that mean in practice? Does that mean, for example, that somebody who has a deportation order but is asserting that they qualify under the settlement scheme but for that deportation order can appeal, and at their appeal hearing argue that they can take advantage of the elevated heightened protection under Article 20 because they were at the relevant time an EA national exercising treaty rights? I don't know the answer to that, but on the face of it, it appears to be a possibility. So these issues need to be borne in mind when considering making applications under the EUSS scheme, which may trigger action which then needs to be considered, but potentially it could provide a favourable route forward at an appeal stage. Moving forward, just to deal with a couple of ancillary issues, and really we're moving back here to consideration of deportation orders made under the new regime against those with settled status. Priya mentioned, I think, earlier the position in respect of those subject to deportation orders under the 2016 regulations and the applicable scheme that applies to determine whether that person will be removed pending their appeal. The position, as we shall see, is on the face of it exactly the same under the Citizen Rights Appeals regulations. There is Regulation 16, which appears to be in identical terms. Priya made reference to the case of Hafiz, how that affects the situation, whether that more favourable regime under the EA regulations is transferred forward. It appears on the face of it uncertain, but leaving that aside, the position is the same. And then again, if you are removed pending your appeal, we have in Schedule 3 of the regulations provision which replicates Regulation 41 of the 2016 regulations. So you can apply to come back for your appeal, and unless that may cause serious troubles to public policy or public security, then the Secretary of State should facilitate that, and you will have immigration bail for the period of your return. I'm just going to move forward and talk about a topic that I alluded to earlier, and this concerns, this is a topic that I'm really speaking about because it arises from a couple of cases, ongoing cases, that I have at the moment from clients who have deportation orders, non-EA deportation orders, but have made applications under the 2016 regulations in order to assert a right and effectively produce a situation where those deportation orders cannot be implemented. So I've made reference there to the case of Harrison, Jamaica, and the second case there, AB Morocco, that concerned an appellant who had been subject to a deportation order, had come back in breach of that order, and had then made an application for a residence card, which had been refused, but he was appealing against it, and that would have rendered his deportation unlawful. So that's the kind of scenario that we're talking about here. So in that situation, going back to the regulations, the grace period regulations, and then the transitional regulations which follow, both of those effectively extend the effect of the 2016 regulations, which I think I mentioned earlier, means that there oughtn't to be a situation where that there is any rush. If somebody has an ongoing appeal, or indeed makes an application within the next month, then the 2016 regulations apply, and maybe there are, in some particular situations, that may still be an option to consider. And finally, I just want to talk briefly about EEA appeals and what the regime will be in respect of those cases, because for deportation orders, what we know is that effectively we're going to be looking back to see whether the conduct was before or after the 31st of January 2020, to see effectively what test applies. We know from various cases, and I referred to SGC there, that the facts and the proportionality assessment must be undertaken at the date of the appeal. But we also know, in terms of EA appeals generally, by virtue of Schedule 2, that the only ground of an appeal is that the decision breaches the appellant's rights under the EU treaties in respect of entry or residence in the UK. And so it's important to try and get our heads around these different provisions in terms of what period we're looking at the date of the appeal. There are in both the grace period and the transitional regulations provisions which appear to amend what's said in Schedule 2, because obviously the position is at the date of appeal in 2021, the reference to rights under the EU treaties doesn't make any sense. So the provisions appear to address that issue, and they are in respect of the grace period regulations. If one looks at Regulation 9, and then at paragraph I, and in respect of the transitional regulations, paragraph 6 of paragraph 6, 1, AA and BB. So we have therefore an overall scheme which enables, on the face of it, somebody to continue to rely on the more favourable regulations as far as criminality for conduct before the end of the year, to have that assessed in terms of proportionality at the date of the hearing, and in the context of EU law, which would apply but for the fact of Brexit. So I'm going to now pass back to Priya, who's going to deal with British citizenship, good character and citizenship.
Thank you very much for that, Mark. Okay, so I spoke earlier about the suitability requirements, and for completeness, Mark and I felt that we should also cover the good character issues that arise for EU nationals and their family members when they go on to make citizenship applications. There is just one particular issue that we wanted to deal with, and in fact, Alison Hunter at the start in the panel discussion touched upon this. Okay, so the requirements for naturalisation under Section 6 and Schedule 1 of the British Nationality Act 1981 include the following: that the individual has to be over 18, they have to meet the knowledge of English and life in the UK requirements, they have to have an intention to continue to live in the UK, they have to meet the residency requirements and be of good character. Now, it's the last of these requirements that I'm addressing here. What I say about good character, though, is also relevant to the residency requirements, because as part of the residency requirements, what an individual needs to show is not just their length of residence, but that their residence has been lawful. In particular, what I'm addressing under the good character requirements is this need for comprehensive sickness insurance that has arisen recently. Okay, so an individual that is aged over 10 has to be of good character if they wish to become a British citizen. If they're not of good character, then their application will be refused. Now, good character is not defined in the 1981 Act. It is defined in policy guidance, and it's very broadly defined. It covers a large number of situations. The first bullet point that I have put under there sets out the sort of circumstances that they consider, but you can see that that includes financial soundness, what they refer to as notorious behaviour, immigration law breaches. And it's the immigration law breaches that they are going to consider the need for comprehensive sickness insurance under. So on the 30th of September 2020, the Home Office updated their good character policy guidance, and it potentially makes it harder for EU nationals and their dependents to become British in how it looks at the need for comprehensive sickness insurance. Now, what the updated policy says is that in assessing whether or not a person has complied with immigration requirements over the past 10 years, the decision maker has to take into account whether they were subject to the EEA regulations 2016 and whether they complied with the relevant requirements. Now, the Home Office has long considered that EU students or self-sufficient individuals who don't have comprehensive sickness insurance or European health insurance card are not compliant with the immigration requirements. Now, many applicants will hold settled status under the EU settlement scheme. And unfortunately, that doesn't really assist them if they have previously been students or self-sufficient. What the guidance says is that to qualify for indefinite leave to remain under the EU settlement scheme, all an individual has to show is that they have been resident in the UK for a continuous period of 5 years. However, that does not mean that they've in any way demonstrated that they've complied with the EA regulations during that period of time, because that simply isn't a requirement of the EU settlement scheme. Specifically on the need for comprehensive sickness insurance, the policy guidance says that comprehensive sickness insurance is a legal requirement for EEA and Swiss students and self-sufficient persons and their family members who are living in the UK with them. If a person did not have CSI, then the decision maker has to look at why they did not have it. Again, they repeat that having status under the EU settlement scheme isn't sufficient because that does not show whether or not an individual was complying in accordance was residing in accordance with the regulations. So what it says is that if an individual hasn't had comprehensive sickness insurance, the caseworker has to consider whether it's appropriate to exercise discretion in their favour. It notes that some individuals may have applied for permanent residency. And they may have been refused that on the basis that they didn't hold comprehensive sickness insurance. But what it goes on to say is that when looking at whether or not to exercise discretion on this basis, what needs to be considered is the reasons why the individual did not have comprehensive sickness insurance. Now, the previous policy guidance that was dated the 14th of January 2019, and that was valid up until the 29th of September 2020, that made no mention of comprehensive sickness insurance. In May of 2020, the naturalisation policy, that was updated, and that made reference for the first time to comprehensive sickness insurance. So this update to the good character policy guidance is in line with that amendment to the naturalisation policy. Now, the difficult thing about all of this is that the guidance does not specifically set out the circumstances in which discretion will be exercised. Will it be enough to say that the applicant did not know that they needed to have comprehensive sickness insurance, that they thought that the NHS was sufficient? It's not known. The guidance doesn't give any sorts of examples of when discretion will be exercised. All it says is that there must be an assessment of the reasons given. So that's quite an unsatisfactory position, and it's obviously important to warn applicants that even though they've qualified for settled status under the EU settlement scheme, there may be issues going forward for them. Okay, now I haven't got very long left, just a few minutes, so I'm going to very briefly just deal with losing pre-settled status through absences. Now, the starting point is that EU citizens and their family members, they will qualify for settled status after completing a continuous qualifying period of 5 years of residence. So those that have been living in the UK for less than 5 years, they qualify for pre-settled status, and they can upgrade to settled status once they reach that 5-year point. Now, a continuous qualifying period, that's defined in Appendix EU of the immigration rules. And what it says is that it has to be a period of residence that began before 11 p.m. on the 31st of December 2020, and which hasn't been broken by one of the following situations. So the following situations include a prison sentence, a deportation, exclusion, or removal decision or order, and absences from the UK exceeding a total of 6 months in any 12-month period. There's some exceptions to that, and I'll go on to have a look at those. But very quickly, let's just have a look at the absences which are not to exceed 6 months in any 12-month period. So we're not looking at a single lengthy 6-month absence. It also applies to multiple trips, which total 6 months in any 12-month period. The rules refer to absences during any 12-month period. So we're not looking at calendar years, we're looking at rolling periods of 12 months. And that's important to bear in mind. Absences are only relevant to the qualifying period. So once the individual has completed the 5-year period, they only lose the right to apply for settled status if they've spent 5 years or more outside of the UK. Okay, so what are the exceptions to this 6-month period? So I've summarized those for you in the slide. And most importantly, what they allow for is a single period of absence that does not exceed 12 months, and which is for an important reason. Now, the important reasons that they list in the guidance include pregnancy, childbirth, serious illness, study, vocational training, and overseas posting. But those are only examples. Now, it's really important to bear in mind the wording of that exception. So applicants are permitted a single period of absence that does not exceed 12 months. So anything that goes over 12 months, there won't be, they simply wouldn't consider it. a single period of absence. So there's reference in those exceptions to overseas posting or vocational training. Now, often a question that's asked is, what if somebody has been in and out for work and that those absences have taken them over the 6-month period? What the wording says is we're looking at a single period of absence. So looking at that simply wouldn't consider that sort of situation. Okay, now what the Immigration Leave to Enter and Remain Order 2020 says at section 13.4 is that if a holder has stayed outside of the UK for a continuous period of more than 2 years, then any leave that they have, where that's limited leave, pre-settled status, shall lapse. So if they have been absent from the UK for a period of more than 2 years, then they lose their pre-settled status. If an individual is granted settled status, then that settled status is only lost if they've been out for a period of more than 5 consecutive years. Okay, that brings us to an end of our session.